Okay, we're going to move on to the second portion of our CLE this evening, to special situations and potential problems. And the area that I'm going to start with is residential picketing. And this is not your ordinary residence. It does happen to be the White House, but it does involve some picketing in front of it. For residential picketing, the public forum test is going to apply to these sorts of activities because your clients are picketing out on the public street or the public sidewalk in front of homes, so the public forum test is going to apply. The government does have a legitimate interest in protecting a residence from unwanted intrusion. The main issue that you're going to focus on in the residential picketing cases is whether or not the ordinance is narrowly tailored. And the main case on point is the Frisbee case, which I think Katie referenced earlier. It involved a ban on residential picketing before about any individual's residence. And what we take from Frisbee is that courts will narrowly interpret laws to avoid constitutional hang-ups. And what the court said was that picketing in front of a residence could be prohibited, that there was a legitimate interest in banning that sort of activity, and moving it across the street or 300 feet away was considered a constitutional limitation on free speech. One of the things that the court focused on in the Frisbee case also was that it really focused on an individual residence. If you could walk through an entire neighborhood, that was okay. So they really looked at the statute itself, the ordinance that prohibited the residential picketing, and said you clearly have ample alternatives because you can continue walking throughout the whole neighborhood so long as you're not just standing in front of one residence. That law would be constitutional. Lower courts, however, vary in the distances that they deem narrowly tailored, when you're talking about no picketing ordinances. California cases, unfortunately, tend to restrict you to the neighborhood over and say that that's completely constitutional and narrowly tailored. In the Klein case, actually, I'm going to go forward. In the City of San Jose case, it dealt with an ordinance that prohibited residential picketing within 300 feet, I believe it was, of an individual's residence, and the court in that particular case said that the 300-foot buffer zone from an individual's residence was constitutional, it was narrowly tailored, and the court in the San Jose case went so far as to say that residential picketing, this is how it characterized it, was a disfavored activity not entitled to a high level of First Amendment protection. So it really was blasting this sort of activity. However, we move forward a decade and we get the Klein decision, which really it repudiated what was said about residential picketing and at the same time said, and we're still upholding the 300-foot buffer zone. So it basically legitimized the activity itself, but still said you have to do it 300 feet away, and that's completely fine.
I just wanted to point out that in Frisbee, because a city that I dealt with had a law that was a Frisbee law, and the law literally said it's prohibited in the city of Palos Verdes Estates to picket before or about any residence. But that makes it sound like you can't picket anywhere in the whole city, because you're everywhere that you are, you're going to be in front of somebody's residence. And the court said, well, but what that means is if there's a person that you're focused on, Dr. Joe lives in this house, you can't focus before or about that person's residence. So if you're, so many feet away and then you're picketing and those are other people that you don't care about, but you're telling about Dr. Joe, right, then that would be okay. But before we did the picket in that residence, we went ahead and wrote to the city attorney's office just to make sure that they understood that their law couldn't be interpreted to mean no picketing in the whole city.
And that's kind of what Katie was talking about. There are many strategies to go about challenging various laws or working with city agencies to make sure that you will not be arrested when you go out to engage in your sort of activity. This particular residence where we're at in this photo would be banned in the San Diego County case and in the San Jose case. We're actually standing right in front of the individual's residence. And luckily, there was no residential picketing ordinance in this particular city. One thing to be cautioned about, though, is if you have clients who are going to start going out to a particular residence, even if there's no ordinance in place, a way to restrict their activity, Katie will talk about a little bit later, may be for the individual homeowner to seek an injunction against a particular group of individuals, banning them from picketing in front of his residence or her residence. So you may find the same challenges even though there isn't an ordinance necessarily in place. So.
Oh, and that's what those big, giant yellow signs that say abortionists are, so that you could stand 100 feet away.
Other courts outside of California have been more accepting of the right to residential picket. In the Thorburn case, I believe the court said there was a 50-foot prohibition on picketing in front of a particular targeted residence, and the court said that the 50 feet is fine, as long as it's from, I believe it was the property line, the people could stand across the street. So 50 feet is better than 300 feet. You're at least not in the next block over. And then in the Kirkby case, the court actually struck down a 200-foot picketing prohibition as unconstitutional. One thing that you need to be wary of is content-based distinctions in terms of residential picketing or any picketing. They may not limit it to just residences, but just say a complete ban on picketing except for labor purposes would not be constitutional because it's clearly content-based and would be subject to higher scrutiny. Like we said, this discussion only touches on residential picketing laws. However, injunctions restricting residential picketing also pose a threat. If you have a particular client or a group of clients that are going out to a targeted residence, and even though there's no law in place, they may come under attack in court, having the individual homeowner seeking an injunction against them to prohibit their activities. So, yes.
You mentioned a moment ago possible private actions that the picketed target might come back with. Do you guys run into situations where you're dealing with, civil suits dealing with, say, accusations of intentional infliction of emotional distress and these, other privacy claims and whatnot?
I haven't personally. I know Kitty has worked on some residential picketing cases, and I'm sure that they would throw the litany at the pro-lifers just to get them removed from the public sidewalk. Did you have anything else to add on that?
Well, I will be talking about injunction cases a little bit later. So that is definitely a tool in the arsenal.
So, and at this time, Katie is going to come and speak to you about the broader free speech rights under the California Constitution.
The federal Constitution, I remarked earlier, the federal Constitution does not protect any sort of speech activity on private property. The federal Constitution is couched in terms of, it's Congress shall make no law, and then through the 14th Amendment that has been incorporated to apply to any government municipality, but not, the idea is always there has to be state action before there can be a violation of the First Amendment. In California, our Constitution is framed differently. It says every person in the state enjoys the right to speak freely. And that opened the door to the possibility that this our free speech right under the California Constitution was broader than the federal right and was applicable against where there wasn't state action, against non-state entities. And it was in that context that the Pruniar decision came down in 1979 that said, well, actually, let me back up here. Because of that, it is very much conceded that it's boilerplate in a number of California decisions. Our constitutional, our state constitutional right to free speech is broader than the federal one. The question is, in what way? How? And a test has been enunciated that under California law, a public forum is an area that the question is whether the communicative activity is basically incompatible with the normal activity of a particular place at a particular time, and which is broader than the federal test of very specific traditional public forum and non-public forum, limited public forum, designated public forum. It's a broader test. Which ironically seems to appear more in federal cases than it does in our own state law cases. So you have a kind of a funny situation where sometimes you get a better deal on the state constitution if you're in federal court than in state court. And then once you've established this public forum, whether it's the same, even under California law, it's the same time, place, and manner test. The same test for time, place, and manner restrictions. That is narrowly tailored, et cetera, content neutral, leave open ample alternatives. Now, the Pruneyard decision, the citation here is to the United States Supreme Court decision. What happened was it went up to the California Supreme Court. Some people who wanted to gather signatures in the Pruneyard Shopping Center and were told to leave by the property owners, and they challenged that exclusion. Went up to the California Supreme Court, and the California Supreme Court, in a somewhat, I don't want to say muddled, but again, playing on this idea that the California constitutional right to free speech was broader than the federal one, said no, that the property owner could not exclude them. It went up to then the shopping center appealed to the United States Supreme Court, which held that there was, on the grounds that this constituted a taking of their property under color of law, that the Supreme Court rejected that challenge, and thus leaving standing the state Supreme Court decision saying that some private property was in fact open for free speech purposes. You did not need state action. Well, actually, let me qualify that. Again, they didn't make quite clear the rationale, as we'll see in a minute. But just the conclusion was that you have certain types of property, like shopping centers, that are generally open, and therefore they have to be open for expressive activity as well. And then along came abortion protesters. And all of a sudden, the Pruneyard decision, had been used. We were moving down from the Pruneyard shopping center, some huge regional shopping center, and you had decisions that were, smaller places, strip malls, and everything was going along fine with, Pruneyard applies here, Pruneyard applies there. And then we got down to abortion protesters wanting to go into parking lots of multi-tenant office buildings and the like, where there were abortion providers. And one of the first was Planned Parenthood versus Wilson. We highlight this one because the Wilson in this case is the husband of Colette Wilson. He was going on the property of a multi-tenant office building, and the court will know that is not a Pruneyard situation. And there was a series of decisions in the early 90s along those lines that these were not, that the multi-tenant building, it had to be a broader invitation to the public. And as the years have gone by, we've seen greater and greater restrictions on Pruneyard. For instance, the court has held that it doesn't apply to, and not the California Supreme Court. These are all appellate court decisions until we get to this one. Appellate court decisions, it doesn't apply to large standalone stores like Costco. It doesn't apply to a shopping center where there's one anchor store and a lot of little stores, like a Trader Joe's. So Pruneyard has been cut back and cut back. It still retains its force when it comes to content neutrality. To the extent that you have a property owner who has, in fact, they are opening up their property and are allowing speech, the speech has to be content neutral. They cannot make distinctions, whether it's speech saying, I think they're trying to prohibit speakers who were urging people to participate in a boycott of one of the stores, and they wouldn't allow that, and the court struck that down. The Snatchco was just walking up to individuals, and the shopping center had a rule against speaking to people about matters not related to shopping center business, and the court struck that down as just basically ridiculously overbroad, which it was. The interesting thing is the California Supreme Court still, it's become quite divided on whether Pruneyard should survive or not. Because at the time, Pruneyard, there was a few cases along the same lines, and it seemed to be a trend. And then that trend died out. And you were left that there's very few states which recognize a broader right for speech on vis-a-vis private property owners in their state constitutions. And so, for instance, there was a case in 2001, Golden Gateway Center versus Golden Gateway Tenants Association, and that was the first time the court had revisited the issue since Pruneyard. And it was a 4-3 decision with the 3 dissenters vigorously arguing that Pruneyard should be overturned. It was just led to a lot of confusion. It was not well grounded, and I think the majority gave them a lot of ammunition for saying that it wasn't really doctrinally well grounded, so they finally confronted the issue: is there a state action requirement under the California constitutional free speech right or not? And the court said, yes, there is a state action requirement. At which point you go, okay, Pruneyard's out. But then they said, we conclude that the actions of a private property owner constitute state action for purposes of California's free speech clause only if the property is freely and openly accessible to the public. So they basically deemed private property owners to be state actors when the property was open to the public. So that you say you can understand why the dissenters are saying, let's just chuck it. But anyway, I mean, Pruneyard does survive. I'm sorry, did you have a question?
I represented SNAPSCO.
Oh my goodness.
the Fashion Valley case, which was I think 2007, 2008, was a California Supreme Court decision, and that was very good for allowing expressive activity in the shopping mall context. And we really piggybacked off that in the SNAPSCO case. But that opinion was written by the woman who's now our Chief Justice of the California Supreme Court. So that's a very good indication that right will continue, at least in a large shopping mall context. And most large shopping malls require significant state action. So for instance, that shopping mall, the Relevant Galleria, all of the parking area is owned by the city and rented to the shopping mall. And you can't have a massive mall that has over 10,000 people a day going into it without significant state action or city action in that case.
But did the court? I can understand why we would have made that argument. Did the court base its conclusion on that argument that that's where here we can find some state action, or we got a big shopping center here?
No, it's just because it's a big shopping center and it serves a quasi-public function because it's a public gathering place. It's a place, at least in the common areas in the mall, as opposed to the individual stores. It's a place where people come together just like they would in a park or a public sidewalk, and so it's accorded all of the same rights.
Yeah, no, I think that and I understand what you're saying about you don't have something that big without having the government having being affected by that. Again, as you say, whether it's we're going to run a bus route close by or something like that, or have special patrols, and there probably will be government involvement. But I think you must be as familiar with the decisions then. That you do have a strong strain of dissenters there who think that Pruneyard should be overturned. And
I don't think that that's going to continue because, especially if you look at the district court decisions, they're pretty strong. Supporting, obviously they're not controlling the law, they're interpreting California law, but they're so consistent, and I just don't see that changing. I think that you probably have fewer people now on the California Supreme Court who would be opposed to that than you used to. So if you look at the Fashion Valley case, there were some dissenters there, but I think that case was probably like a 7-2 decision. It wasn't a close decision.
I think we can check on that.
You can check.
Okay. Yeah.
I think Justice Blue was opposed to it.
Yeah. Chin.
Right.
Anyway, I'd be happy to talk with you about it. So, just one other thing to be pointed out in context of the restrictions that a shopping center can put on speakers. So that's what happens. So you've got your large shopping center, and then they come up with their rules, and which then can be challenged if they're overly restrictive, as was done in the Stashko case, and overly restricted or content based, and but what another court has held is that they're merely failing to abide by time, place, and manner restrictions in a shopping center or in a in a mall or something like that is not in and of itself grounds for finding that someone has interfered with the business of the shopping center or the business of a store. In the case of Hamburg versus Walmart, the plaintiffs were arrested. They had been arrested for trespass, or actually 602.1, which is interference with the business. And the grounds for that was they had been told to stay in one place, and they didn't, and so they moved off for that place. And but the court, and then they I can't remember if they were prosecuted or not, but anyway, they ended up being the plaintiffs in the lawsuit suing Walmart, and they. The court ruled that mere failure to abide by a shopping center's time, place, and manner restrictions did not in and of itself constitute the elements of interference with business. So the I don't remember. You up next, or I keep going? Okay. The next topic is another area, another group of laws. Is the Freedom of Access to Clinic Entrances Acts. That we have a federal face law and we have state face. Federal face, this was passed in 94, and it prohibits intentionally injuring, intimidating, interfering with someone, but the key words to this law are by force, threat of force, or physical obstruction. And so even though whatever vagueness there might be in intimidate or interfere, the core elements of a face violation are force, threat of force, or physical obstruction. And the victims are people who have been reproductive health services providers or wish to obtain reproductive health care services. So it's a crime with a very specific victim class. And where we are litigating right now, we were just talking about this, that the face civil remedies are where the DOJ seems to be focusing its attention right now. We are seeing a number of cases across the country where they are bringing actions against sidewalk counselors and over truly petty incidents. Even if you accepted their allegations as true, you would say, literally, you're going to make a federal case out of this? And one just this past week was dismissed on summary judgment, a case down in Florida where they went after a sidewalk counselor for, and they go after what happens is you never have a true victim. You have the U.S. Attorney General bringing the action, it's Holder versus whoever, and seeking relief of a $5,000 penalty for the victim, the quote-unquote victim, and $10,000 or $15,000 for the just in civil penalties, which is a substantial intimidating effect on sidewalk counselors, because then the DOJ gets in there and says, okay, tell you what we'll do, we'll cut that down if you'll agree to stay away from the clinic. And because it's so clear from having been involved in these cases, they filed a lawsuit and conduct minimal discovery. They're really just filing these to intimidate pro-lifers. And again, this case that just came down a few days ago, it was dismissed on a summary judgment motion, or summary judgment granted for the defendant, and the court chastised the Department of Justice, saying it couldn't conceive why they had brought this case other than possibly to intimidate the pro-life defendant.
What were the facts of that case?
This pro-lifer, there was a clinic that had an entrance and an exit driveway, and I guess there was, for some reason, the entrance was off some sort of private property, so you couldn't go there, so they tended to, the pro-lifers would go around the exit and try to hand out information there. Every once in a while, someone would drive in the exit, and in this case, someone drove up and stopped, and she went over and was talking to them. And during that time, I guess another car who was exiting, had to sort of go around. And but generally, but then an officer. But what it appeared that there had been an officer stationed there specifically to watch her activity.
There was an obstruction under there.
Yes, that was obstruction. That's what the court said. Merely having to stop for a few seconds, and this is somebody who's actually leaving the clinic. So she didn't obstruct the person who was going in because they had voluntarily stopped. and anybody who was coming out was not, they weren't being interfered with in their attempt to obtain any reproductive health services. And so the court, has some rather harsh words for the DOJ for having even brought the case. What we've seen in some other cases is supposedly, using force against escorts, like in a case we're involved in Kentucky, where the escorts they were actually, locking arms across the sidewalk, and then they would let a patient walk through and then close up again. And so someone was trying to hand out information and bumped into the arm of an escort while doing so, and the next thing you know, the DOJ is suing them for the whole litany of penalties and things like that. And what makes this case more interesting is the DOJ didn't file the lawsuit for didn't file the lawsuit for almost 11 months after the incident. And meanwhile, this person had moved out of state. They were not even going to the clinic anymore. They had been gone for months. And so they're seeking these penalties and this injunctive relief, and it's like, it is a puzzlement to all of the attorneys who are working in these cases across the country why they pick a particular place and a particular person. Because, this, again, even if you said, well, we got to keep this guy from doing this, he's not even there anymore. So it's a scary phenomenon, but we're very heartened by this decision that, maybe when that news of that gets around, maybe the DOJ will reconsider some of these sort of frivolous cases that are bringing. Yes?
Does anyone challenge this on their 10th Amendment, claiming that this is completely asinine that the federal government's even involved in this?
It went through a whole slew of challenges after it was first passed.
10th Amendment?
I believe so. I mean, I would have to check, but I mean, it was...
I'm curious how they got around that, do you know?
Because, I mean, they had their congressional findings, was it a commerce, maybe it was a commerce clause?
Commerce clause.
Yeah, I believe, that was probably it then. Yeah. So I think that they had in their congressional findings enough Commerce Clause sort of language in there about it. So
that was actually a case that a judge said, yep, this...
Yeah, again, there were a number of initial challenges in the early, after it was passed, saying it was, because I feel fairly confident that was covered.
I would expect that.
Yeah. So, yes?
I was reading an article about the Florida case a couple of days ago, or yesterday, and it mentioned that, I guess, the DOJ, the Obama administration DOJ, had brought 8 cases, criminal, and in the 8 years before that, there had only been 1. Is that really representative of the enforcement of the federal case?
Again, civil. I don't know. Criminal,
Okay.
Yeah, criminal, I think tends, probably was, I'm trying to remember now. I mean, definitely civil. There was a huge uptick. And again, these cases, when you just look at the face of them, there's so little to the allegations. We're not talking about someone pulling a gun or anything like that. I mean, the allegations on their face are so minimal that you can't believe that the DOJ is wasting their time, and again, even if they were true. So we have, say that here are the criminal penalties if you want to scare your clients, but there, again, this is just, this was the government's effort to, in '94 to look like, we're getting tough about a national problem here, et cetera, and then, not to be left behind, California jumped on the bandwagon and passed its own version of FACE, and which is quite similar. I mean, there's some differences in wording, but very similar. By the way, you should notice both Federal FACE and Cal FACE apply to churches as well as abortion clinics. So keep that in mind if you're ever in a situation where someone is, you represent a church or someone going to church where the church is being picketed or something like that going on, that you could use FACE in those circumstances too. And we were, we've got this up here, but I don't know of a single civil case under Cal FACE. Again, it seems to be more in terrorem to have it there.
So is there a private right of action?
Yes. And one of the most interesting aspects of the FACE, the Cal FACE law, is that they actually ordered the Attorney General to compile statistics, annual statistics of anti-reproductive right crimes, so we could keep track of what they're up to. And these reports are hysterical. You can find them online, and you'll see this 20-page report analyzing 5 quote-unquote anti-reproductive rights crimes by every possible grid, in terms of what county it took place in, whether there was property damage, almost always no. Was anyone convicted? Almost always no. And because these crimes they are simply reports. They don't have to have resulted in a prosecution, much less a conviction. So these are simply reports. And so in those 6, well actually 7, includes the grand total of 65 incidents of anti-reproductive rights offenses were reported. And so, to me, it's the best evidence that we have that the so-called, this so-called wave of violence against abortion clinics is totally fabricated. In fact, we use this in the Hoy case to challenge their whole justification for the law. I think that's it. Oh, no, it's me again. Okay. Although most times, we talked about the Cal face with the federal face with the injunctions. In those cases, it's the DOJ bringing the action. In most cases that we see, the injunctions are brought by private, by abortion providers, and they can allege a variety of tort claims, trespass, assault. A very popular one is simply violation of California's constitutional right to privacy. They allege that on behalf of their patients, that this is interfering with their patient's right to an abortion or to. So they seek injunctions with a variety of speech restrictions, usually all rolled up with other, do not trespass, do not damage property, do not make threats, do not talk to our patients, do not murder anyone, do not, it's just, they're all just all balled together. You have the things that they really want, and there is stay away from the clinic, keep, stay 25 feet away from the clinic, because, there's usually they try to erect a zone, and that's really what they're after. The other is just kind of window dressing to make the court think that, gee, we had to bring this action to prevent all these terrible things from happening. And, so because there are cases that say that a clinic can actually get attorney's fees on the private attorney general statute against picketers, and if they bring this action and they get an injunction, and they are, in a couple of cases, have held that they are entitled to attorney's fees. And so you have to be very careful, and I know I'm jumping ahead of the slides here, I'll admit. When they have this smorgasbord of things that they want to be enjoined, separate out the things that are livable from the things that aren't, because you might end up having to go to the other side and say, these we can agree to because we're not doing them anyway. These are the only things that we don't agree to, the distance one or the something like that, or don't approach that. Except we're not agreeing to those. Everything else is okay. And just to set the record that the clinic, they did, because later on they will go and say we had to get, we were forced to litigate to get this injunction to prevent them from assaulting our patients. Well, no, we agreed to that long ago. The only thing we were litigating this over was free speech, stuff that is constitutionally protected free speech. As far as the legality of these injunctions, the constitutionality of these injunctions, the prime case is Madsen versus Women's Health Center, and in that case, a clinic had sued the pro-life protesters, and a state court had imposed a number of restrictions, including a 35-foot zone around the clinic, and it went up to the Supreme Court. And in evaluating the constitutionality of the injunction, the Florida Supreme Court had used the traditional time, place, and manner test of narrowly tailored, deserves significant governmental interest, ample alternatives, content neutral. And so when it went up to the Supreme Court, the question was framed as to whether that was appropriate test or not. And the Supreme Court said, well, no, that's not quite stringent enough. We need a test, because this is an injunction which has the possibility of being used in a biased manner, only against some people. It's not a generally applicable law, so it could be targeted at just certain people. Because of that potential, there should be a somewhat more stringent, is the exact word, somewhat more stringent standard. And that standard is, may burden no more speech than necessary to serve the asserted governmental interests. And there's two problems with that test. The first one is, nobody knows what it means. Nobody knows how this differs. May burden no more speech than necessary differs from narrowly tailored. You know, they tell us it's more stringent, so we just take their word it's more stringent. But, you know, if you asked any lawyer to look at two, you know, say a particular restriction and say which standard does apply, you know, which standard works, or does it violate this but not that, the test is just almost, you know, you only know when they tell you whether something burdens no more speech than necessary. The bigger problem is the second line, to serve the asserted governmental interests. Does anybody see what's wrong with that part of the test? Yeah.
What's the sort of governmental interest? Sounds like everything.
Well, all close. No.
Wasn't this a private action against private?
Precisely. This is a private abortion clinic which is bringing this. What is it doing asserting governmental interests at all? And why is the court tailoring relief for this private party according to its assertion of the government's interest? If the government wants to keep the sidewalks clear, it can do so. It's not up to an abortion clinic to say, hey, give us a 35-foot zone because people are congesting the sidewalk. You know, it has a right to say, okay, don't congest our driveway because people need to get in and out. But when you start getting down to, well, people are causing congestion on the sidewalk, then, you know, that's now out where the government should be worried about it, not a private party. And the government should be the only one who has the right to either make a generally applicable law to deal with the situation, or just, you know, the clinic just has to live with it. So that's the problem. That's the problem with this test. But this is the test for whether or not injunctive relief is passes constitutional muster. Then the way these, fortunately, we do not see as many injunction cases as we used to. We used to see these very regularly in the 1990s. They were coming up all over the place, and the typical, but they do still come up now. The typical way it gets started is your client is served with a complaint and TRO papers, you know, right off the bat. You know, show up in court 2 days from now. And in fact, in some cases, they are served only with the TRO after it's already been issued, because the party has gotten a TRO without notice to the opposing party, which is, it violates California rules of court. And it also is unconstitutional that, you know, under Carroll versus President and Commissioners of Princess Anne County, you may not get a TRO without that restricts free speech rights without notice to the other party. Unfortunately, when a clinic goes into court to get their TRO and they're saying we got a big hurry and sorry we couldn't serve the other side, but we, you know, terrible things are happening, give us a TRO. Nobody's there on the other side to point out to the court. It's a catch-22. You know, who's going to tell the court you can't issue this without notice? Because there's no one there to tell them that. So then the second thing that happens then is, if a court does issue a TRO, particularly one that restricts speech, it is very difficult to get those reversed. It is very, once the court has imposed some sort of zone, to get that modified or reversed, it is really hard, because then for a couple of reasons. One is just it becomes the new status quo. And you know, then it's almost up to you to show that there are problems with this new status quo. Is the way, I mean, effectively the burden that gets put on you. The second thing is that you lose the ability to prove that there wasn't a problem, which is something we're going to get into. Things like when you're talking about documenting and videoing activity. If your clients are in a situation where there seems to be a lot of hostility on the other side, you better document the activity, because if something like this happens, you know, and they're moved across the street or down the street or something like that, you are no longer in a position to say, you know, to prove that there was, you know, no, they weren't blocking cars, no, they weren't causing congestion, no, there was no, because, you know, you're now out of the area. So it causes a real problem with then proving your case retrospectively to say, you know, then it's just basically your client's word against the clinic workers. And we can talk a little bit about that too. Anyway, so I mean, in opposing an application for TRO, the traditional grounds are that there was no irreparable injury. You know, what's the hurry, Your Honor? these people, the longer people have been out there, the better. If you say, people have been out there for 3 years, 4 years, 5 years, nothing, what's a few more weeks, at least till the preliminary injunction hearing is going to hurt. And that injunctions are intended to preserve the status quo, especially TROs are intended to preserve the status quo and not alter the status quo, which is what these TROs would do. And also, they have to show continuing threat of harm, not just some sort of triggering incident which brought them into court. So they should have to show that there's a continuing threat and not just a one-time incident. One of the tools that we have to know about in challenging, if somebody brings one of these actions against a client of yours, is the CCP 425-16 motion to strike, because they would. How many of you are familiar with that? The special motion to strike. Slap motion, anti-slap motion. I'm sorry. Yeah. So this is it. Wherever a cause of action arises from the exercise of constitutionally protected rights in a public forum, you can shift the burden to the other side. You bring the special motion to strike instead of an answer. You bring the special motion to strike, and the other side then has to make a prima facie showing of their case without doing any discovery. And we have had some cases where and then the other thing is you can also, if you prevail on your motion, get attorney's fees. So you're turning that around on them and making them have something to lose too in bringing these actions. Well, we were talking about this earlier, about the possibility of stipulating or reaching some sort of informal agreement with opposing counsel about some of the things that they're asking for, just to avoid the thought that you're litigating to protect your client's right to trespass. No, that's not what's going on. You're litigating simply to protect their free speech rights, and that would defend yourself against a possible attorney fee liability later on. Your client against a possible attorney fee liability. Now, the other thing that happens with injunctions is once a clinic has gotten an injunction, they love to then apply them against everyone, all pro-lifers. And this is a sign that was up at a clinic in Birmingham, and the clinic had gotten an injunction against certain protesters. I think they were Operation Rescue. I think it went back to the early 90s. And keeping everybody more than 20 feet away from the clinic, and I guess the clinic and any person going. So then they proceeded to put up the sign and say, okay, this applies to all pro-lifers. And unfortunately, had the pro-lifers in the community intimidated for years and years and years until it finally came to our attention through we happen to be in Birmingham for another lawsuit. But this is an issue that has been litigated in California successfully on a couple of occasions. One, Rich Catterdahl over there. Wake up, Rich. People versus Conrad was a criminal action for a violation of an injunction, and the court, because the clinic, I think did it on its face say it applied to all persons with notice, or that was just how it was they interpreted it. I can't remember now. I think it was just how they were interpreting it.
Right. It was in the federal case in front of Weigel that Planned Parenthood actually got the court to amend the thing to
say all persons with notice. Yeah. I mean, that's one thing you really want to look at any sort of proposed order or anything like that. Are they trying to get it to apply to everyone with notice? Because they will definitely try to do that. And in this case, I tend to think that the injunction simply said those acting in concert, which is legitimate language to have in an injunction, the defendant and those acting in concert with him, but it has to be understood the right way. As the court in Conrad said, acting in concert does not mean mere mutuality of purpose is not sufficient. The fact that they're both pro-lifers, they both want to stop abortion, whatever, that's not enough. It has to be acting in concert. And acting in concert, the way to understand that is, the proper understanding is, okay, this person, party A has been enjoined. They can no longer do this action. And what is concomitant with that is they can't get anybody else to do that for them. And that's what acting in concert liability is. It's not just someone who's friends with them, is in the same pro-life group, something like that. Acting in concert means that the second person is doing the action on behalf of the first person. because otherwise the court would not have jurisdiction. They only have jurisdiction of the first person, and then it's only the second derivatively from the first as being sort of their agent. And that's very important, because then one way to make courts understand that is to say, if this person, if party B is in contempt, then party A must be in contempt too, because he can only be acting for party A, otherwise he wouldn't be in contempt. And that sometimes makes courts understand how close the connection has to be. It's, again, not mere mutuality of purpose, not some association. What gets me about these cases is that there's something almost McCarthy-esque about the way that they go after when they're trying to show someone acting in concert. It's, show us all the groups you've given money to, meetings you went to, rallies you went to, was so-and-so there. They're just trying to come up with any sort of association they can. And so, in a sense, they're attempting to violate the right to association in order to violate the right to free speech. And by the way, in California, there is protection in discovery for the freedom of association. There's a case, Britt versus Superior Court, which it gave, said that the freedom of, or the right to association, there was a right to associational privacy that applies into the area of discovery, so that a person doesn't have to disclose their associations, unless the asking party, the other side, meets a higher burden of showing that it's a compelling interest in getting that information. Okay, claims other than the First Amendment. Equal protection is something that when you get into the content-based, viewpoint-based area, there's a interplay between the First Amendment and equal protection, and the courts aren't really that clear sometimes which it is. Whether something, when you say an exception for labor picketing, is that a exception, is that an equal protection problem or a free speech problem? And the Ninth Circuit just sort of blends the two together and subsumes them under the First Amendment in free speech cases. And actually the Supreme Court has also held speaker-based distinctions are unconstitutional. So you don't even, that's a form of First Amendment viewpoint discrimination when you say, put extra burdens or privilege certain groups for speech, the way it came up recently in the FEC versus somebody last year, where they struck down one of these campaign finance laws that put extra burdens on corporations, and the court said that that's just a substitute for it's a speaker-based distinction, which, because it can so often be an attempt to suppress certain viewpoints. When you suppress certain speakers, you're usually trying to suppress certain viewpoints, and so that they ruled that was unconstitutional. The equal protection, I just want to point out, we made that argument in the Hoy case. We added claims for equal protection under the state and federal constitution, mainly because I didn't want to fall between two stools on this. We weren't clear at the time we filed the complaint. Are they saying it's the speech, or are they saying it's the speakers who are specially treated? Is the escort speech because it's facilitating access, or it's just because of who they are? And so we put in claims for equal protection, and the Ninth Circuit in effect said it's all that. And I'm really glad we did do that, because I think it's going to make collecting attorneys feel a little easier. But it also, it reminds me, one thing I didn't cover before about when you're framing your relief in these actions, okay, injunctions are great, but funny things can happen to your injunctive relief claim, like the city all of a sudden getting religion and stopping its bad activity. So make sure you put in a claim for nominal damages, make sure you put in a claim for declaratory relief. Make sure that if something should happen to your injunctive relief claim, you've got something to fall back on as a victory. Otherwise, again, the city could just walk away from its bad activity, and you'd be left empty-handed under a federal law in terms of attorney's fees, because you need to have a judgment that actually changes the legal status of the parties under federal law. Yes?
But on that note, as I understand California's private attorney general statute, generally, if you succeed in getting a government entity, for example, to change their course of action as a result of the litigation, if you prove that they have changed their action because you would file a lawsuit, you can still collect.
Yeah, well, yes, California does subscribe to it's called the catalyst theory. And California does subscribe to that, and it, which is another reason to, even in your federal lawsuit, you throw in a claim under Civil Code Section 52.1, so that you can. That's another way to make sure you're covered in terms of getting attorney's fees, because that any violation of right by threats, force, or coercion, which would be sort of any sort of official action by police, that in contravention to your rights. You've got that as another claim, and that would also then get you into a catalyst, theory where you could assert a catalyst, a right to fees under a catalyst theory. So, and then the freedom of association, and I think we talked about that a little bit, about the right. Again, it's mostly comes up in the same area of right to privacy in these areas. And I, in terms of throwing in a claim for that, to my mind, it's sort of like a free exercise claim in that, I think if you can't win it on free speech, you're probably not going to win it on freedom of association. If you can't win the right to stand on the sidewalk, the fact that you want to stand with somebody else is probably not going to, make a difference. Due process and vagueness. If a law is just too vague to understand, that is another grounds for challenging it. And you can't get some sort of clarifying interpretation from the city, then that would, you be sure to include a claim for vagueness, which is a due process violation, because people have the right to know what is forbidden. And I think that brings me into my part. So.
Okay, stay with us. We're almost there. Now to the important part, advising the client. What can pro-life advocates do to protect themselves? And these are just some helpful tips that we would encourage you to explain to your clients based on our experience with certain cases and certain litigation. We would recommend bring a friend with you. If your clients are going out to the clinic, if they're going to hold an event, bring somebody with them. If they're going to go sidewalk counsel, bring somebody with them so that they are not alone and cannot come against whether it's security guards or clinic personnel making false accusations that your clients are doing some sort of wrongdoing. Take pictures and video. Carry a recording device, whether it's an audio recording or a video recording. This is what really saved us in Walter's case, is the fact that we had everything on video. We had the clinic director take the stand. I was talking to some people over the break, and just fabricate a story that she was practically crying on the stand. Walter came at her. She was afraid for her life. And we had the whole thing on video, and this never happened. And so her credibility was just completely wiped out by this video that we had. Document the activities of escorts and clinic workers. If somebody is going to go out to the clinic on their own, I would encourage them to keep a journal and write in it who they came in contact with, how many people, what was the nature of their communication with people going into the clinic, any interactions that they had with any security guards or clinic personnel, so that if something comes up later in the future, they have a journal of everything that's transpired, and that can be used as evidence in their defense.
Allison, one more thing to talk about the friendly cop. Make a note of the name of any friendly police officers.
Yes.
It's very frustrating when someone says, oh, but they said that the clinic called the police officer, he came out and he said everything we're doing was just fine. What was his name? I don't know.
This is true. It's important to document every person that they come into contact with. And it may even be a security guard who says, okay, you're allowed to do this, or I'll allow you to do this particular activity on our property. And then once word gets to the actual people inside the clinic that this friendly security guard has allowed you to do something that the clinic doesn't want you to do, he may change his story and say, I never told you that you were allowed to do that. So it is important to keep down the names of every single person and document the conversations as they occur. If you have any questions or if your clients have any questions about what conduct is permissible, call us. Tell them to call you. If they're out on the sidewalk, this is what I tell my clients. If I know, they generally call me ahead of time to say, hey, we're going to go down to this clinic today. This is what we expect to do. So I know people will be there, and I know to keep my cell phone on me. And many times the police show up, are trying to harass them, get them to move across the street, and I'm able to negotiate with the police, if they'll talk, in that instance. So tell your clients not to be afraid to let the police know, I'm going to call my attorney, or will you talk to my attorney and explain to them what law you think I'm violating. Specific advice in dealing with bubble zone laws, this is very difficult to advise clients about, particularly in light of just the random enforcement of these various laws. And because the laws vary in their scope. Some of them prevent walking in front of a clinic at all. Some of them have the 8-foot buffer where you actually have to get consent before you get within 8 feet of the person. So it's important to know exactly what type of bubble law you're talking about before you give any advice to your client. There's also a problem with enforcement. These laws are enforced so differently depending on the police agency that you might not know. For example, the Oakland bubble law was designed to mirror the same one that is out in Colorado. However, Oakland is enforcing it, saying that you can't actually extend your arm, whereas in Colorado, you're allowed to extend your arm. That's not an unlawful approach. So it's really important to know ahead of time how the city or the police agency intends to enforce this law. And always err on the side of caution. If there is a buffer zone, it's best to just advise your clients that if somebody is walking towards them, stay still. If the buffer is 8 feet, make sure it's 10 or 12 feet, and you stop walking or approaching them, and just let them come to you if you want to avoid a potential arrest situation. Conflict with law enforcement. Our clients have a particular viewpoint that many law enforcement officers don't respect or agree with, and so police officers will use their badge and use their authority to sort of bully them and get them to move under this threat of arrest. It's important to advise your clients, I'm sure we all do this, to speak reasonably with the police, be polite, be respectful, but at the same time you don't have to agree or tell them to agree with everything that the law enforcement officer is telling them to do. We say to try to accommodate reasonable requests when you can. However, if the officer is telling you that you have to go across the street, or if the officer is telling you that you're not allowed to hand out literature, we're not telling our clients to not engage in the free speech activity that they're entitled to. But if an officer says, can you just stick to one side of the driveway, or can you just stick to one side of the sidewalk and not walk back and forth, or can you stay off of the lawn and just stay on the concrete? If that's reasonable and it's not going to substantially interfere with your client's activities, go ahead and be nice and do it. You don't have to stand up and protest every single thing that the law enforcement officer is telling your clients to do if it's not going to substantially interfere with their objective. Ask to speak to a supervisor or watch commander. We tell this to our clients because many times the officer on the street doesn't necessarily know the law, doesn't know the history of your client being in front of a particular clinic, and may just misapply the law. And a quick call to a supervisor or a watch commander can clear up the situation very quickly. This actually happened to us at a clinic in San Bernardino. The one where I told you was sued for telling us to hold the signs on our tiptoes. We went back out there every single year. We go there for the Mother's Day event and hand out flowers and Mother's Day cards. And the shift had changed, and so there was a whole new set of beat cops that come out there. And one of them was telling us that we couldn't be on this one particular area of sidewalk, and we had fully litigated this issue just 3 years earlier. And we just said, no, we litigated this and we're allowed to be here. You might want to call a supervisor. And they did, and that resolved the issue. They said, oh yeah, you are. And that just took care of the situation. So it doesn't always have to be confrontational. It can be resolved. Situations with law enforcement or conflict with law enforcement can be resolved just by talking to a supervisor. We tell our clients to call an attorney if they really feel that their rights are being infringed upon, or they feel that they're really being targeted by the police, and the police are either telling them, move or I'm going to arrest you. It's very important to just call an attorney in that situation. We don't want them to be arrested even if it's a false arrest, but even more importantly, if they're just mistaken and they don't understand the law and it ends up being a legitimate arrest, and we have to deal with those situations. So it's best to just call an attorney in that situation. If some of our clients want to monitor these developing laws, like we were talking about some bubble laws, or this mobile billboard laws that are cropping up in various cities, one way for them to monitor the laws that developed in this area is to keep an eye on city council agenda. This happened down in Southern California. There was a letter to the editor in a paper, and then the issue came up on the city council agenda the very next week. And that's just a way to keep abreast of what laws the city is trying to pass to restrict your free speech activities or your client's free speech activities. Watch the newspapers. I like to get on anti-life websites and just on their email lists and see what they're talking about, where they think the activity is, and who they're going to target next. It's a good way to know to be on the offensive and not to be on the defensive and be caught off guard. Check with the state attorney general and legislator websites. If an instance of speech restricting legislation comes up, please call us so that we can advise you of how to challenge it, so that we can work with you. There's ways to document certain activities, to challenge the legitimacy of these regulations prior to them being enacted. Sometimes it works, it doesn't always work, but if you start early, you at least are making a record ahead of time. And then resources. Be prepared. We talked about this before. If you can know in advance that there's an activity that's going to take place, you will be far better prepared to know the law, maybe even speak with law enforcement ahead of time, and really it just provides for a smoother event so that your client's rights aren't being threatened off the cuff and that they can go out there and accomplish the objective that they set out to accomplish. You can call us ahead of time if you know about an event. If your clients are being told that a particular activity violates a particular code section, you can give us a call. Chances are we've researched this type of issue in a very similar situation, and we have briefs. I think that brings me to the next slide. We've done research, we have briefs, we have pleadings that we can give you. We have attorneys that we have networked with all over California that we can put you in collaboration with to help you in this situation. And Life Legal does offer funding on a case-by-case basis. If you agree to take a case pro bono, we can front some of the out-of-pocket costs to challenge the constitutionality of many of these lawsuits, or many of these ordinances. And we're almost at the end, the last slide. And it's a great one to end with, because we've been talking about all these very restrictions and our rights, and when is it appropriate to stand up for your rights versus the government's authority to restrict your rights. And the thing that we don't want to forget is what you're actually fighting for. We've discussed a lot of legal mumbo-jumbo, but I think Colette talked about it in the beginning, that we are really protecting the rights of people who are on the front lines, who are saving babies every single day. And it's sometimes overwhelming because we do come up against very biased judges, and it seems like it's an uphill battle, but we must never, never give up, because this is what we're really fighting for. Thank you.